think people should stop thinking that contracts are standard, especially boilerplate clauses are standard and need not be negotiated. Boilerplate clauses usually appear at the end of the contract. For example, dispute resolution clause, entire agreement clause, variation clause, indemnification clause, so on and so forth. It is the last thing that people look at it when they enter into a contract, but usually these are the first thing that you should look for when dispute arise. Why is it so? For example, assuming that you have contracting parties are two Malaysian entities and disputes arises, and then you notice that the arbitration clause which provides that the governing law should be Malaysian law, but parties are to submit their disputes to arbitration with a seat in Singapore. So what then entails? Costs and the time needed to travel to Singapore for the arbitration. A next example would be assuming you have a contract, and then subsequently parties agreed something to vary the contract. You may conclude this variation by way of email, WhatsApp, or maybe verbally. And then subsequently you find out that your counterparty denies it and you want to sue for its breach. Then you find out that there's a variation clause which says that any amendment to the contract has to be made in writing. Sometimes some contracts will provide that it should be in certain form, for example an addendum. What then entails? Again, subsequent amendment may end up being non-binding because you never comply with the conditions imposed in a variation agreement clause. What makes it worse is when you have an entire agreement clause which binds you strictly on the conditions that you have agreed in the variation clause. And because parties' rights under boilerplate clauses are purely contractual in nature, as a first principle, court will always give effect to its plain meaning depending on the words used in a contract. For example, for indemnification clause, you can't go beyond what has been provided. On the other hand, if it's too broad, you may end up having to bear a huge amount of damages for events that you haven't even contemplated. I will conclude by saying this: although boilerplate clauses are pre-written standard clauses, that's how people label it, but usually this could be the cause or even a determining factor as to the outcome of a litigation.